The Procurement Act is a recipe for accelerated state failure. It was assented to today by President Cyril Ramaphosa. The Act is intended to replace the Preferential Public Procurement Framework Act, the PPPFA. If implemented, it would drive up procurement costs and it will degrade state performance and service delivery because of its complicated and bad design, as well as its requirements based on race, nationality, and other non-value-adding criteria. Its ambiguous and its contradictory clauses, which abound, will form the perfect cover for self-enrichment and corruption. At its core, the Act attempts to deprive state entities of their choice under Section 217 of the Constitution between, on the one hand, expensive preferential procurement and on the other, normal value for money procurement. And it seeks to compel now all state entities to procure goods and services only from an artificially small pool, restricted on what? Well, based on race, nationality, and other criteria which drive up price and degrade service delivery. While the Act does not explicitly state political connections as a requirement, it will facilitate this on a scale never experienced before. In the way that the Act restricts international business, it likely also falls foul of several of South Africa's international trade obligations. And besides, already, companies that can offer the best value for money increasingly avoid doing business with the state due to the excessive political complications, the ethical problems, and the legal uncertainty. Under the new Act, this trend is set to accelerate, and it will leave the public exposed to state procurement increasingly from companies who are able to win tenders, yes, but on everything except price and quality. In part, the Act represents an attempt at countering Cyril Constitutional Court judgment on procurement 2 years ago, in which we protected the choice of municipalities and other state entities to determine their own value for money procurement policies. The Act purports to achieve what the minister was then not lawfully able to achieve through regulations. Yet it also remains unconstitutional for similar reasons. What the minister could not do, Parliament cannot do either. Nor Parliament nor the minister is empowered to bind an organ of state to specific preferential policies. Section 217 of the Constitution assigns this discretion to organs of state themselves. The Public Procurement Act is harmful and unconstitutional, but it is not yet in force. What Cyril will now do is to subject this final version to careful scrutiny to determine appropriate steps in countering it and retaining possibilities for normal value for money procurement stemming from our 2022 Constitutional Court victory and otherwise.